Saved you from new legislation. So, normally if we have some time on Friday, I'll try to highlight some of them. I do want to talk a little bit about it. I did a different, which doesn't help us in this situation, but I did a kind of different presentation on the slides. We got a lot of feedback for the last few years that please don't put all that, don't read us the slides, don't go through this too much. So what I did this time is pretty much limited to the bill, what code is affected, and like a brief summary of what it is. Because really, if you need to know more about it, go to the code, not what's on the slides, not what we talk about. Go to the code and read it yourself. So I gave you that information on that. So as you go through it, there's a lot less of the details there because the details are in the code. And now that you have access to the code online, it shouldn't be a problem to go ahead and look at it. And if it changes, you're going to the source instead of looking at something that I presented 2 years ago or Debbie presented 5 years ago. So that's why this is set up the way it is. As I said, at the top is what bill it came out of if you want to look at the original bill, when it's effective, what statute, and then what it's talking about. And again, what I'm going to try to do, how much time do I really have? I got 9 minutes, so I'm going to try to go through some of these. The forfeiture, be sure and look at it because they're changing it. It really doesn't affect you as far as the calculation. There's a very complicated calculation. I had to do algebra to figure out how the heck they're doing this. But it does change how you're handling it. There's going to be a new fund involved. So we'll have that on the funds table because the prosecutor is going to have a forfeiture fund on that. There is also, the way the formula is set up, there will always be a residual that is going to the state for the common school fund because of the way it's set up. There's always going to be at least a little bit left, which you haven't had in the past. So you're going to see more of that coming through. If you have questions specifically on this, let me know. I'll be glad to discuss it with you. I had a page and a half of notes on this one. The service of process really didn't, we tried to correct that. It didn't quite get corrected. You probably know there's some issues with that. What they did say, what they did change in this that affects you, whatever clerk collects the fee, regardless of which sheriff is serving the process, they're going to give it to the auditor in the county where they collect it. So we're hoping that evens out overall, but that was the change that went into effect. So if your clerk collects it, they're giving it to you to put in your sheriff's pension fund. Okay, 296. The big thing with this, just to be aware of, is if someone has put, either the county or the city and town has put an order for like an unsafe building that they have corrections they need to make, if that property goes up for tax sale, the person who purchased it has to abide by those, get those corrections, get those repairs made. So that's a new thing with that. Again, you might get questions about it during a tax sale, but they do have to comply with that, and that has to be part of the notification for that property. When you buy this, you're going to have to make these repairs to bring it up to a safe, just for the safety part of it. I don't know, this only really affects Marion County right now, but just as kind of the wave of the future, that's a new allocation area, like we don't have enough with TIFs, so just so to kind of have a heads up on that. Okay. This will affect your council and commissioners. It just clarifies what an administrative meeting or administrative business is that is not a public meeting. It just puts some more language in there when they can have training, when you can talk about internal controls, when you can do things like that that are not considered a public meeting that has to be published and open to the public. This does not affect your recorders, and I did talk to them about this when I did their new ledge, but if you supply a copy of a public record in electronic format, you email them, you cannot charge for that. If they come in the office and you print it out, then you can do the charge for copies. And again, that does not affect the recorders. And I don't know how many of this will affect because I just don't have that kind of knowledge base. But this is a new law that allows the county, if they own land that is fairly small, that they can now either give that to adjacent property, and if the adjacent property owner doesn't want to accept it, they can still assess it to that adjacent property owner. These are small pieces of property, probably, carve it out, just so you're aware of that. Okay, this was adjustment or a modification on the home rule statute, and it's limiting in some way that you cannot license, register, or certify if there is an Indiana code for that. So if they have to go through Indiana statute to get their license, you can't add to that unless it has to do with public safety or public health. So contractors, things like that, where you have where they have to register with you before they can do public or any kind of building projects. If it's a public safety issue, you can require them to register locally. And this affects your public works contracts. So, the state already had this, but it adds it for any local ones that are above 150,000, that your contractor has to have a drug testing program in place. You have to have proof of that in order to award the contract to them. So you want to read that before, or have your attorneys look at that before you do any public works contracts. And this is increasing the ability for the invitations by quotes by phone, fax, or email. It is now not restricted to projects under 25,000, and it eliminates, if you're doing it, if you're mailing them out, there are certain deadlines that you have to do before you open it. And with this, if you're doing it by phone, fax, or email, it gives procedures to do that, and you don't have to have that 7-day period before. This one is just a clarification. You've already really been doing this, but they got it in the statute on those community corrections grants, that probation, pretrial diversion, and jail treatment programs. You're already getting grants in that, so you know about it, but now it's in the statute. Okay. Again, I don't know, but this is one you want to look at if you have or know about short-term rental properties where you can require a permit for that in your county. If you want to do that, of course, that would require an ordinance. You can charge a fee for the initial permit of up to $150. So if this is something that you're interested in looking at for your county, this is where you're going to find the information on that. On your innkeeper's tax, I know that's more the treasurer. They did change the statute. DOR will be prescribing a form for all of the counties to use for the hotels to turn in their innkeeper's tax, and they will be providing summary data. So this is a little bit of a change on that. And again, I don't know how many counties this affects, but if under current statute or this new statute, if you for a person that wants state licensing for a daycare, they have to provide proof they've either met the local qualifications or there isn't a local qualification. So you may be getting contacts from them. So if somebody comes in saying, I need something for my license, this is maybe what they're talking about. So you'll want to look at the statute on that. This does allow a county by ordinance to contract or enter into an interlocal agreement with a town court to do your ordinance violations. I think that's already happening in some places, but this is giving some formal procedures for that. So if that is something that that your county is doing or you're doing, sending your ordinance violations to a local town court, there are procedures for that, and it does require an interlocal agreement. I'm not going to go over this because they talked about it yesterday, but there is new funding, a new formula to use for funding your community mental health centers. If you have questions about it, again, it's another one I had to draw out, get my algebra out and trace it all out to figure out how they do it. So if you have questions about it, let me know. Last year, under New Ledge, we talked about you could dissolve your solid waste district. Some counties went ahead and did that. One of the issues that came up in at least one county is there was a council member who was also a solid waste employee that now became a county employee, which is in violation of not being an employee and holding a position on a governing board. This just gives you an out for that to allow them to work through the end of their term. Again, I don't know how many counties that affects, but just so you know, that is in there. This was touched on yesterday when Dave Bottorff was talking, but the way they're going to go in the future for the clearinghouse is to use the Trust Indiana Fund. So if you are using the clearinghouse to do your tax offsets from the tax return, it's going to go, after the next year, go through Trust Indiana, so it's going to set up a fund for that, just so you're aware of that. You'll have an account. You can immediately remove the money if you're not, but you can leave it in there, just so that you're aware that's how they're going to do the payments starting in the future. They talked about this yesterday, so I'm not going to go into a lot of detail, but on establishing that local income tax rate for correctional facilities, I just want to point out, because I've already had questions on it, it does not restrict when you get that rate in, what you can use. It's either operational cost or capital cost for your jail facilities or your rehabilitation facilities. So you're going to be the one controlling that fund, so when that money comes in, it can be either of those costs. We've had a few questions on this even before it came out. The reimbursement that you get from the state for housing level 6 felony does have to go in the general fund, which it always did, but you're going to have some additional tracking because the state wants you to use that money on housing felon convictions. So you're going to have to track when that comes in and be able to show that that was then used by your jail for the housing of your felon. Okay, again, this is going to affect your commissioners more, but before you can do construction on a new jail or reconstruction on it, you do have to prepare or obtain a feasibility study, which is part of the statute now. And this is for someone going through the economic improvement districts that deals with your abatements. The intent and petition used to be filed with the commissioners. It's now being filed with the county auditor. So I think you were getting them before anyway, but now they're just going directly to you on that. I think Stephanie will probably hit on this a little bit tomorrow when she's talking about the highway report, but they did change for that 50% of your MVH funds that have to be spent on the highway. They changed it from maintenance to prevention, and they gave a definition of that. There's still some gray area in there, so I think she'll talk about that, and we'll be working through that throughout the year, just so you know. Again, to be your highway department should be tracking this. I don't think that's going to come on you, but it is something they may be asking you for help with. Okay, this is important. They did change the date. It used to say in the statute that we had to notify auditor of state by March 1st if you had not filed a highway report, which wasn't due till June 1st. So it really didn't make much sense to do that. But they have changed the date, and we will be complying with this statute. So if you have, again, Stephanie's going to talk about this highway report tomorrow, but if your county does not submit a highway report by June 1st, we are certifying that list to the Auditor of State's office, and they will withhold your MVH funding until you comply. So we haven't done it in the past, but it's something to look forward to in the future. So you want to encourage your highway departments to get those annual operational reports in. This is kind of important. They did eliminate under this the requirement for a purchaser, if the property is conveyed, to pay the amount that was put in the tax sales surplus fund. That's just been taken out of the statute. That is the briefest highlight I've ever done of new legislation, so appreciate it. It's time for your break.